Hi, I'm Jim Alder. I'm an NFA gun trust attorney. I'm going to try and explain the bronze level trust so that if have purchased one, you're able to understand what it means, how it works, how you'll need to complete it if we're sending this trust to you to be executed in your location and not meeting with me in my office so that I can explain it to you. The bronze trust is our basic entry-level trust. It's set up so that it manages only your NFA weapons, not your other weapons like a 22, your handguns, your shotguns and such, but only NFA weapons. You're the sole trustee of that trust, and you don't have the ability to add others as co-trustees. A trust, first of all, as we look at the title page of your trust, a trust consists of three roles. There are three roles. You fulfill or occupy all three roles. That is the trustee, which is the manager role. The grantor is the person creating the trust, and the beneficiary is the third role. This concept of a trust or trust relationship originated in England, and it came about because of obligations that accompanied land ownership. As a landowner, you had an obligation to serve the crown, and you might avoid some of those obligations by granting title to someone else who might avoid the obligation as the title holder. In making that grant of title, you reserve to yourself the right of the beneficial use of the property. So you're the grantor, you're the person creating the trust. The person that you grant title to is the trustee, and they hold that title in trust for your benefit. But it's an empty title. That's all that they have is title. In making that grant of title, you actually reserve to yourself the right of the beneficial use of the property. So you're the beneficiary. The important concepts here are that trustees have the right of possession of trust assets, and beneficiaries have the right to the use and enjoyment of trust assets. We're using those principles in a gun trust to work around the restrictions in the National Firearms Act, or the NFA, that say that if you own one of these weapons titled in your name, any unapproved transfer of the weapon is a felony punishable by up to 10 years in prison and up to $250,000 in fines. The word transfer is defined by the statute to include selling, conveying, mortgaging, pledging, and loaning the weapon to any other person. But the word loan is not defined by the statute or by the regulations. So the question is, if we're at the range and you allow me to shoot your weapon, have you loaned it to me? I understand that ATF field agents may tell you, no, that's not a transfer of the weapon. But technically, I think you have. I think you have loaned the weapon to me. I don't understand that loan requires that I not be in your presence. And the concern is that if I hurt or kill somebody in the use of that weapon, will a prosecutor have the same opinion as the field agent? Or will a prosecutor be looking to expand the use or extend the coverage of loan to my use of that weapon to prosecute us both for causing that harm? You for transferring the weapon to me, and me for accepting the transfer of that weapon. As a beneficiary of your trust, I have the right to the use and enjoyment of your weapon, that NFA weapon. So I can use it. I have that right, and it's not a transfer. In our silver trust or gold level trusts, you also have the ability to add co-trustees, and if you wanted to lend me an NFA weapon to use, or any other person, you can make me or that other person a co-trustee of the trust, and then that co-trustee can have possession of that weapon even outside your presence, and that is not a transfer. That's what we're attempting to do with a gun trust, is extend the use of these weapons to other individuals and avoid the transfer that you may have heard about. So in Section 1.01 of your trust, you see the trust name. In Section 1.02, you see some of the powers that are reserved by you as the grantor, the creator of the trust. You have the right to amend the trust or restate the trust. A restatement is simply a completely new trust document. It's the same trust. It has the same name and the same original signing date, but it's the same trust, just a new document that includes all the new provisions. So if you were to upgrade in the future to one of our higher levels of trust, the silver or gold for instance, we would prepare a restatement for you. just a completely new trust document with all the different provisions that constitute that trust and make it work. Okay, you also have the ability to revoke this trust, but a word of caution. If you ever wanted to revoke your gun trust and you have already transferred Class 3 weapons into it, you have to transfer them back out, either to yourself or to other persons, and then revoke the trust. The fear is that if you revoke the trust first, before transferring the weapons out of it, you are now in illegal possession of those weapons. So just a word of caution, I don't imagine that you would ever want to do that, but if you for some reason did, you must first transfer the weapons out and then revoke the trust in that order. You'll notice at the bottom of that paragraph 1.02, section 1.02, a reference to this being a grantor trust, and that simply means that for IRS purposes, you, the grantor, are responsible for any income earned on trust assets and to pay tax on that income. You report that income on your personal 1040. The trust is identified by your Social Security number. It does not have a separate tax ID number, and it does not change the way that you pay taxes at all. And if you did have any income, and that's likely only to be a capital gain, if you bought a weapon, sold it later for a higher price, you technically have a profit or a capital gain, and that should be reported on your personal 1040. That's what being a grantor trust means. Now, to exist, a trust has to have something in it. You'll notice this in section 1.03 of your trust, that we start the funding process of the trust by assigning $10 to the trust, and that's any $10, the $10 in your wallet, in your coin jar, whatever. You can do whatever you want with that trust, but that's how we bring it into existence, is by assigning $10 to the trust. Then you'll fund the trust with your NFA weapons by completing the transfer, by submitting a Form 4 or Form 1 if you're manufacturing a suppressor, building an SBR, something of that nature. That's how the trust will be funded. 1.05, Section 1.05, it refers to a Schedule A. This is important. You're required to keep a copy of this Schedule A, a list of your NFA weapons that you have, and that looks like this. So if you can see that there, hopefully, your Schedule A. That Schedule A is what you will use to list out your weapons. Also included in the materials that we send you is a checklist that gives you an example of how to describe a Gemtech Outback 2 suppressor on that Schedule A, so you know what goes in there. And what you do on that Schedule A when you are completing an application is list the weapon, provide the description and the serial number of the weapon in the first box that you see here, right here. And in that box, you list that serial number and its description, but you leave the other columns blank because you don't have that information, the tax stamp number and the date that the tax stamp was issued. Okay, you make a copy of this Schedule A. You sign and date it down here at the bottom, but you make a copy of that Schedule A and send a copy of it with a copy of your trust with each application. Don't ever send the originals because you won't get them back. Okay, when you get the tax stamp back, then you write in the number on the original and the date it was issued. We will also be sending this Schedule A to you in Word format. So save that Word file to your computer, add that information as you receive it to that Word format, that Word file as well. So keep a running list of the weapons that you acquire, the NFA weapons that you acquire on that list, and that is a table built into the document. So if you are fortunate enough to acquire more than the number of boxes that you see on that table there, put your cursor here in this last field and hit Tab, and you'll generate a new row and keep expanding onto the next page. So just keep adding to that list as you acquire those weapons. Now, as I mentioned previously, your NFA weapons are the only thing part of that are in the bronze level trust. Your other weapons that you may have are not part of it. You don't ever list those out anyway or supply them to the ATF&A form. Okay, so if you have questions about how that Schedule A is used, don't hesitate to contact us and ask. But hopefully that trust checklist and the user's guide that's included in your materials will explain how to fill that out and how to complete that. One note on sending applications to the ATF. If you're submitting multiple applications at the same time, I recommend that you send a copy of the trust with each application. I have had some clients that have had some success at sending multiple applications and one copy of the trust. However, the problem is that now, it used to be that applications for one state were handled by one examiner back at the ATF. That's no longer the case. If you send multiple applications, they may be divided among multiple examiners. And if you've only sent one copy of your trust, that copy may go to one examiner, and then the other examiner or examiners don't have a copy, and your applications that they receive will be rejected. You'll get a letter from the ATF saying, please submit a copy of the Declaration of Trust, and you'll be delayed. So to avoid that delay, just send a copy with each application so that you have no hiccups, no delays, and you get these things processed as soon as possible. Okay, so moving on now with the trust, you'll see on page 3 you have a little expression of your intent in creating the trust in section 1.06. And this basically just says that you're creating this to own, possess, and transfer NFA or firearms and accessories, especially in this trust, NFA firearms, and to be able to share the use of those firearms with others through the trust. Okay, flip to Article 2 of your trust, and that's and in section 2.01, we refer to how trustees are determined for the trust. Now, you are the current trustee, but this article spells out how successor trustees are picked and their qualifications, qualification requirements. To be a trustee of the trust, a gun trust, you need to be 21 because the ATF requires that to have possession of an SBR or an automatic weapon, a person must be 21. So there are some that suggest that trustees might be 18, but the ATF doesn't look on that lightly. They want you to be 21. You don't want to mess with them and argue with them. Trustees must be 21. Just be safe. Okay, but they have to be 21. They have to be of sound mind. Trustees have to be, they can't have a felony conviction at all. They cannot have misdemeanor domestic violence convictions either. They must not otherwise be prohibited by any federal, state, or local law. So all the requirements that you see on a Form 4473 when you buy any weapon apply here. Using the trust is not a mechanism to avoid those requirements, those obligations. You can't be a fugitive from justice, illegal alien, substance abuser, so forth and so on. Trustees also need to be or become familiar with the National Firearms Act and the restrictions it places upon use, transfer, and possession of these weapons in particular. But to identify who serves as a trustee of your trust, what we do is say, when I die, and you'll see this in section 2.02 of the trust, that when I die, if you've got the basic bronze level, it says, or when I become incapacitated or when I die, look first to a separate revocable living trust that I may have for just my general estate planning, and the trustee of that trust will serve as the trustee of this trust. If I don't have that, but I have a power of attorney, the agent under that power of attorney will serve as the trustee. If I don't have a power of attorney, but a guardian has been appointed by a court to manage my affairs, that guardian will serve as my trustee. And when you pass away, in similar fashion, first look to the trustee of my separate revocable living trust. If I don't have one, the person who is nominated by my will to act as my personal representative will be the trustee. You don't have a will, well then, if the court has appointed a personal representative to manage your probate estate, that person, again, will be the trustee of the trust. Now, one of the differences between the basic bronze and the bronze plus is in the bronze plus trust you have the ability to name people, and that is done on the Schedule B. So your Schedule A was for your NFA weapons, but in the bronze plus trust you have a Schedule B that allows you, where your successor trustees are listed. And so it looks again like this right here, and you will list those persons here. They'd be listed in order of who will serve. And the Bronze Plus Trust says, look first at the person serving named on Schedule B, and then if they're unavailable or I've left that blank, Again, just like the basic bronze, the trustee of my separate revocable living trust, so forth and so on. Okay, that's who is named to serve as the trustee of your trust. Now, let's get to Article 3. Article 3 deals with administration of the trust during your lifetime. The trust is there to take care of you and provide for you. Okay, so if you become incapacitated, the successor trustee that's determined by Article 2 can step in, take over management of the trust for your benefit, for the benefit of your spouse and anybody dependent upon you as well. And that's spelled out there in Article 3. Now, 3.01 has some important language in this bronze trust. You are the primary beneficiary during your lifetime, but the purpose of this trust is to extend the use of trust assets to others. So what we say in these bronze levels is that a person with whom you are engaged in firearms-related activity, including but not limited to hunting, shooting, attendance at a gun show, or any such similar activities broadly defined, may be a beneficiary during the activity and for its duration. Okay, so anybody that you're shooting with or hunting with is defined to be a beneficiary of the trust, and so as a beneficiary, they have that right to the use and enjoyment of trust assets, and if they use trust assets in your presence, that's not a transfer of the weapon, because they have that right under trust law. And that's how we work around the restrictions in the NFA. Now, the reason that I give the little spiel about how trusts originated is to illustrate the differences between trustees and beneficiaries as far as the rights that they have. Beneficiaries have that right to the use and enjoyment of trust assets, but they don't have the right of possession. There are some that argue or suggest that beneficiaries can have possession of trust assets. I believe it's a very gray area, and therefore recommend stay away from that cliff face and make it black and white. Trustees have possession, beneficiaries can use and enjoy trust assets. If you want to lend something out to someone else to use outside your presence, you need to upgrade to the silver level where you can appoint co-trustees and sign weapons out to co-trustees who can have possession. In this bronze trust, your lifetime beneficiaries can use and enjoy trust assets, but their use needs to be in your reasonable physical proximity. Okay, you need to be able to monitor what's going on with that weapon at all times. Okay, so that's how we extend the use of trust assets, NFA weapons, to others in this bronze trust. Now, because of this, because you're trying to extend the use to others, this is one reason why you never put anything else into this gun trust but the weapons. If you put bank accounts, investment accounts, properties and things into this trust, you could be exposing them to others' access or use potentially, and that's not something you want to do with those things. And conversely, your general estate planning trust is not really conducive to NFA weapons because it restricts who has access or the benefit of trust assets, and you don't have the ability to add others on the fly typically, or in short notice, in short order, and it's not set up to facilitate that or allow that. So the trust has a different purpose. You only have NFA weapons, and that's it, nothing more in a basic bronze trust or any gun trust. You never put any other assets into it, unless you had maybe a pool of money, a bank account to buy weapons with, but that may be all. Okay? So, but if continuing on with Article 3, if you become incapacitated, the trust is there for your benefit, to be managed for your care and those of the care of your dependents and spouse. You'll note in 3.03, Section 3.03, guidance for providing benefits, it says that your trust or successor trustee should give consideration first to your needs, then the needs of your spouse, then the needs of anyone else dependent upon you, but only then to preservation of trust assets for beneficiary use and access when administering this trust under this article. The purpose of that statement is to encourage the trustee to try and avoid liquidating the unique assets of this trust, because your purpose is to preserve them so that your beneficiaries can continue using them. Ultimately, trustees do have that discretion. Successor trustees have the discretion to sell trust assets if it's necessary for your care or the care of your family. And so if they do need to do that, in this section we give them some idea of where to find appropriate values, like gunbroker.com, Blue Book of Gun Values, or a dealer's catalog. Now in Article 4, the trust goes on to explain how the trust needs to be administered upon your passing. The trust becomes irrevocable at that time because you are the only one as the grantor with the right to make changes to it. So we stop using your Social Security number at that time and get a separate tax ID number for the trust. And this trust is also set up, it's intended to be a comprehensive management system for your NFA weapons, to explain to your successors the processes and the rules for handling these weapons so that they don't get in trouble when they come into possession of them. You know, when you're gone and you with a knowledge of how they're supposed to be used or treated, handled, are not around. Okay, so this hopefully keeps them out of trouble, gives them a rule book or guidebook as to how to handle and administer these weapons. Okay, so we go into a little bit of that in 4.02, referring to administration of NFA firearms, and 4.03 that details some of the processes, the forms and procedures that will be necessary after your death to transfer weapons from the trust to the beneficiaries of the trust, your remainder beneficiaries as they're called. It references the Form 4 transfer to a buyer, if a weapon's being sold to a buyer. Form 5 transfer, though, if it's to a beneficiary of the trust, and no transfer tax, the $200 is not paid on a transfer to a beneficiary of the trust. But if the beneficiary wants to go straight to their own gun trust instead of going to them individually and then having to do another transfer to get it to their own gun trust, they can elect to do so, but that is a Form 4 taxable transfer, just like you'll do to get weapons into the trust. Your successor trustees are directed in 4.04 to coordinate with other representatives of your estate, make sure your final expenses, taxes, debts, and obligations are settled upon your death. Now in Article 5 we get into the distribution, identifying the remainder beneficiaries who receive trust assets when you die, and in the basic bronze what we do here is similar to appointment of successor trustees, in that we say, follow my other dispositive documents that I may have. So if you have a will or a separate revocable living trust, the gun trust directs just follow the distribution provisions in those documents and distribute to the same people. Okay, and if you don't have those documents, it says follow the intestacy statutes of the law or laws of the state of Utah. Intestacy means dying without a will, and so it's the probate code provisions for determining who inherits when you don't have a will. So we're looking there for your nearest living relative or class of relatives and distributing to them. In the Bronze Plus Trust, again, you have the ability to name those people individually or by name specifically. So that is done on the Schedule C. So if you look at that, you'll see the Schedule C here that identifies who receives trust assets when you die. So the Bronze Plus Trust says, look first at that schedule. And if nobody's available under that schedule, then do the same thing like the basic bronze, follow my other dispositive documents. If I don't have any, the laws of intestacy of the state of Utah. Okay? Now, if any of those beneficiaries are under the age of 21, the trust will continue, and this is detailed in Section 5.02. The trust will continue for their lifetime, or sorry, at least until they reach the age of 21. The trust will continue. The trustee will hold those trust assets or their share of trust assets, whether it's cash or weapons. The trustee can use it for an underage beneficiary's care, for schooling, medical expenses, whatever support is necessary. But when the beneficiary reaches the age of 21, they are entitled to receive their share outright, again, whether it's weapons or cash or whatever it may be. If there's an incapacitated beneficiary, the trustee will hold that beneficiary's share in trust, use it for their benefit until their share is exhausted, but not make an outright distribution to them because they can't manage it on their own. Now in Article 6 of the trust, you have some basic trust guidelines. I call it sweater language because it's kind of like a sweater that you pack to take on a trip. You may not ever need it, but you pack it just in case. So you've got some guidelines in there about some basic trust administration issues, and then the trustees' powers. Now in these trustees' powers provisions that you see in 6.04, the trustees' powers include all the powers set forth under the Utah Uniform Trust Code, but we go into much greater detail here about handling NFA weapons. So there's a few sections here, 6.05, 6.06, that give some direction, some clarification about how these weapons are handled and what the processes are. so again your successor trustee doesn't get in trouble handling these weapons. And this is a real issue. We've dealt with a few situations. In fact, at the time of the making of this video, just a few weeks ago, I met with a fellow whose mother was handing out suppressors that her husband had owned to her sons upon Dad's death, and saying, here, you take this one and you take this one. Dad would have wanted you to have these things, and had no clue that she was committing that transfer felony by just giving them away. And luckily this fellow happened to know a dealer with the SOT licensing, so he was an NFA dealer, and the dealer happened to warn him and say, no, go talk to Jim, get a trust set up. You've got to go through these processes before you can take possession of those weapons. And may have saved their bacon, kept them out of some serious trouble with the law. So that's its purpose, is to keep your successors and family members and whoever comes in contact with these weapons out of trouble by giving them some explanation, making sure that they're aware of what is required in handling them. Now, your final article of the trust is simply definitions, so that we know what's intended by the use of the various terms that are throughout the document. Okay, so when you receive this, the gun trust, you're going to take the trust and find a notary, and it has to be signed in front of a notary. So you'll have your signature page looking something like this. You see your signature as the grantor and trustee. You're going to sign here, and then the notary is going to have a notarization page looking like this, where they will notarize your signature to complete the trust. Okay, so deliver that, take that to a bank maybe, or if you know a notary, take it to them, sign those 2 pages. You should also sign your completed Schedule B and Schedule C at the same time, so that you have them. Now, your Schedule A will only be signed when you're ready to make an application and you've listed the weapons that you're purchasing in it. Then you sign it at that time. If you're making a paper application to the ATF, you're going to make a copy of all those documents and send that copy to the ATF with your application again. If you're building an SBR, or if the e-form system comes back for Form 4 applications and you're able to use that, you're going to need to make a scan of this trust. If you're meeting with me in my office, I make that scan for you and send it to you. But if you're signing this at home, you're going to need to make that scan on your own. We'd appreciate if you email a scan, so we have one on file in our records, and that we can replace yours if you ever lose it, misplace it somehow. But you're going to need to make a PDF scan of your documents and be able to upload that to the e-form system when you're making that online application. I think it's also a great idea to keep that PDF of the trust on a thumb drive in your gun case when you're out and about, so that if you do ever need to want to provide it, say to law enforcement, if you're confronted about possession of the weapon, you have that available. Don't put it on your phone, because if you give them your phone to view it on a smartphone, well, then they could also potentially look at everything else on your phone, and you may not want them to do that. So put it on a separate thumb drive where it's isolated and they only have the right to look at what you give them, make available to them. So if you have any other questions about signing your trust, using your trust, refer to your little trust, the user's guide that's included, and that checklist that we send you as well. If you have questions that aren't answered about how the trust is to be used or set up, please don't hesitate to give us a call or email, and we'll respond to questions as soon as we possibly can. Please, hope you enjoy it. Thanks for using us and setting this up. And we will also keep in contact with you to advise you as to changes in the law. As new regulations are issued that affect the use of the trust, we will email blast all of the gun trust clientele, keep you informed of those changes and how they affect your use, and advise you as to what you may need to do or want to do if there is something adverse. Okay, so once again, thank you, and enjoy your trust. Let us know if you have questions. Thanks.